Hello, I am Brian from Seoul Law Group, and we are an English-speaking law firm based in Seoul, South Korea. We're back with another law video, and today we'll cover everything you need to know about induced drunk driving in Korea. I'm drunk, so I called the driver to drive my car for me, but the driver had just left me. Can I drive my car? If it is to avoid immediate danger, then it is okay. If not, no, you should not. What is Daeri driver service? Drinking parties are a common and universal tradition in Korean companies. As a result, the designated driver service became common and popular in Korea. It is also called Daeri 운전 or just Daeri. Daeri means to substitute or to do something by proxy. When you call a Daeri, then the driver will come to your spot and drive your car to your place, and you may just sit in the passenger seat. The driver earns the money by taking you home by your car, and you do not find yourself drunk driving, even though you brought your car to the party. Sounds like a fair trade. A problem could occur if the designated driver decides to take advantage of you by claiming an additional fee. And when you refuse, they just leave you. As you do not have any other option, you park your car in the parking lot by yourself, driving a few meters. You are now induced to commit drunk driving. If the Daeri driver has an ill intent, they may film you driving your car. A Daeri driver could also call the police, report that you had driven under the influence, and the police will ask you to take a sobriety test. Unfortunately, that shall be enough to be considered as a crime of driving under the influence. You should not drive when you are drunk, either on the road or in the parking lot, and that is the law. This is a classic dirty trick, but still, a lot of car owners get pushed over by this. No matter what, you had driven a car and you were drunk. That makes you guilty. However, recently, some lower courts have started to decide that those types of drunk driving are not guilty. 2019 Gojang 162 decision, decided on June 5, 2019, was one of those. Let's go over the case briefly. The defendant had already been punished for drunk driving 2 times before. The defendant called the Daeri driver, and they had a quarrel. The Daeri driver parked the car on a road in front of a motel. The car was not parked neatly, and there was some distance between the right side end of the road and the car, which may cause an interruption for the traffic. Some cars even had to cross the yellow center line of the road to avoid the parked car. The defendant had to drive the car into the motel parking lot while there were no other cars nearby. The blood alcohol content was 0.072%, which exceeds the standard. Defendant was caught by the police, who were mobilized upon a report. In this decision, the court judged the act of the defendant is not punishable on the ground of defense of necessity. To satisfy necessity, the act must be an act with reasonable grounds to avoid impending danger against one's own or another person's legal interest. To fall under the act with reasonable grounds, the act should be the only method to avoid the danger. It should also be the least damaging method to the victim. And the protected legal interest must be a superior benefit to the damaged interest. Lastly, the act itself shall be in accordance with the spirit of the whole law. In this case, it is true that the defendant had committed drunk driving. However, he drove his car only for the good traffic on the road and to avoid a possible car accident. And there was no other option but to drive his car into the parking lot, as the defendant could not ask for parking from other passersby. The driving distance was only 10 meters. Overall, the court judged the defendant's act as an act of necessity and therefore a justifiable act. 2017 Gojang 1158 decision of Ulsan District Court is another one that had sentenced non-guilty to a drunk driver with similar reasons. The defendant had called the Daeri driver and made him drive the car to the defendant's home. A quarrel occurred between the Daeri driver and the defendant, and the driver left the car and the defendant on a one-way, two-lane roadway. The defendant drove the car for 300 meters and parked in a nearby gas station. The defendant called the police and reported that he had committed drunk driving. The blood alcohol content was 0.140%. In this case, the court decided that the act of the defendant consisted of a crime. However, the court also decided that the act of the defendant was an act out of necessity, which is stipulated in Criminal Act Article 22. The court judged that the driving of the defendant was to avoid a possible car accident that may have been caused by this car stopped amidst a narrow road. Moreover, the defendant had only driven for about 300 meters, and he stopped driving once he arrived at the gas station. Lastly, the defendant had turned himself into the police right after driving. In summary, the drunk driving of the defendant was to achieve and protect a superior interest of the law, and that is justifiable. However, you must not think that every drunk driving after a Daeri driver left is justifiable. It is basically a crime to drive when you are drunk, no matter Daeri driver was there or not, but only justifiable in certain cases mentioned above. For example, in 2017 Gojong 389 decision, decided on September 7th, Seoul Southern District Court decided that the defendant was guilty. The defendant called the Daeri driver to drive his truck, and the Daeri driver parked in front of the destination. The defendant asked the Daeri driver to park again as the truck was blocking the entrance of the shop. The Daeri driver refused and just left. The defendant got into the truck and moved 20 to 30 centimeters for the convenience of the guests. The defendant was drunk and it was 3 o'clock in the morning. In this decision, the court did not accept the defendant saying that it was a justifiable act. It was 3 a.m. and the shop was closed. There was no urgent need to secure the path of the guests of the shop. The danger was not impending in this case. The defendant drove his truck for the good of the shop, which is kinda nice, but that shall also consist of a crime. It was not until the last few years that the court started to view this kind of induced drunk driving as non-guilty. However, you must remember that drunk driving itself consists of a crime, and you need a strong justification to defend yourself. Moreover, satisfying the requirements of the necessity is never an easy job. There must be an impending danger or a possibility of danger to occur, such as a car accident. Well, I hope this video was useful for you. If you have any questions or concerns about induced drunk driving in Korea, let us know in the comment section below, and you can find more information on sewllawgroup.com. Thank you and see you next time.